Good morning, everyone. Thank you so much for having us today in this show with the attorney, the Office of the Attorney Margaret W. Wong and Associates. Today we have one of the best attorneys in the law firm. Well, all of them are awesome, but the attorney that we're going to be talking today with is one of the attorneys that I would say has an answer for you. He has a lot of experience. He also has a very good name, which means liked, if I'm not wrong, which is really good to be talking to someone who his name is liked, because he can bring light to your life, giving you some answers regarding to immigration. But let's start to the attorney Noor Chamas. Good afternoon, attorney. How are you doing today? And thank you for having us.
Good afternoon. Thank you for having me.
Your name means light, right?
That is correct. The name in Arabic means light.
Okay, that's good. It's good to know. Yeah. And it's good that always we can have an answer coming from you. And I would like to start by talking in general about what's going on in the south border of the United States, because over 30,000 people entered through the border in the last few months in the United States in the last year, 2022. That's why President Biden came up with a new rule, at least for Venezuelans, Nicaraguans, Haitians, and Cubans, about entering through the border. And he instated the parole, the humanitarian parole for all of them. But what happens with all of that people that entered before October 13 last year? They entered on a parole through the border, and they are in the United States. What do they need to do right now? Because I understand they are in a removal proceeding.
Yes. So first of all, when you enter the United States on a parole, it's considered you don't have any status, but it's considered a lawful entry. However, you are placed in removal proceedings. If you are placed in removal proceedings, you still have to, attend your immigration court proceedings, and you would be eligible to file for whatever relief is available to you legally. So I know a lot of people coming from those specific countries are likely looking to file for asylum. And they do that because they're afraid to return to their countries for specific reasons, related to those countries. But also, the countries that are designated TPS countries, what they can also do is, of course, if they entered before a certain time, because there are requirements about when you can enter, they can actually file for TPS. If you file for TPS, you can actually have your removal proceedings dismissed if your TPS is approved. But ultimately, if you file for asylum, you would get a hearing before an immigration judge to present your asylum case. If you succeed, obviously you get asylum status, and then ultimately you could become a lawful permanent resident. But it's quite a long process. But essentially, if you are placed in removal proceedings, you have to go to immigration court, and then you have to file for whatever relief you are eligible for legally.
Okay, thank you so much, Attorney Noor. And then one of the questions that we're receiving very, very often is, I entered through the border, I surrendered at the border, they let me in, and they gave me a court date. I filed for asylum, and then I had a court hearing. I attended to that court hearing by myself, and they told me that I need to go with an attorney to the next hearing. So what is that first hearing for? What is that? What do they do there?
So whenever you are put in immigration court proceedings, you are issued something called a notice to appear. On the notice to appear, there's a series of what are called factual allegations. Usually there are 4 or 5 factual allegations, sometimes more if there's a more complicated case. And then underneath that, there's the charge of removability. The charge of removability is basically their claim as to what section under the law makes you removable from the United States based on those factual allegations. Normally, when you go to your first master calendar hearing, that's what the initial hearing is called in immigration court, which is in criminal court similar to an arraignment. That's where you're supposed to plead to your notice to appear. So you either admit or deny the factual allegations in your notice to appear, and you either concede or deny removability based on the charges that they've brought against you. Now, you are not required to have an attorney with you in immigration court. The judge does advise a lot of times what they're called respondents who are in immigration court. He does advise people to get attorneys because it would be better for them. But you don't have to have an attorney. And the judge will also tell you in immigration court, you do not have a right to have an attorney at the cost of the government. You have a right to have an attorney at your own cost. And usually what they do is they ask them, do you want more time to find an attorney? And they give them a list of either low cost or free attorneys that they can call to see if they're willing to represent them. So after the first hearing, they'll give them some time, depending on the judge. They could give you 6 months, they could give you less, they could give you a little more to find an attorney. By the next hearing, if you don't have an attorney, the judge could give you some additional time to find an attorney, or at some point the judge will say, well, we're going to need to proceed without an attorney at this point because we gave you enough time to find an attorney. So they'll have you plead to your notice to appear without an attorney being there. But usually after that, they'll still continue your case so that maybe you can find an attorney to help you fill out any applications that you might be eligible for. But essentially at the first hearing, that's what you're going to do. You're going to plead to whatever is in your notice to appear. It's always better to have an attorney because the attorney understands the law and understands whether you should admit or deny an allegation or whether you should concede or object to a removability charge. So that's the first step in immigration court.
Okay, that's a very good answer, very good information, very detailed, and thank you very much for giving us those details because a lot of people call to the office and they say, well, I need an attorney for this second hearing because I went to the first one and the judge gave me more time to find an attorney. But what happens if this person finds the attorney just 3 or 4 days before the court hearing? Is there a chance for the attorney to do something there?
So if it's an initial master calendar hearing, then usually it's fine. The attorney usually is able to go to the hearing. Sometimes the attorney, if the attorney can look at the notice to appear and it's simple enough, the attorney can still do the pleadings given a few days. But there are times where the attorney can tell the court that I was just retained as the attorney. I need more time to prepare for the case. So I'm not prepared yet to do pleadings. And so the judge usually will grant the attorney what is called attorney prep time. And so they'll continue the case to a later date to allow the attorney to review the client's file, review the notice to appear, and then come back and see if they're prepared to plead to the notice to appear at that point.
Okay, thank you very much, Attorney Noor Chamas. And don't forget the phone number is 216-279-3984, 216-279-3984. You can talk to the attorney, Margaret W. Wong, or any of the attorneys in the law firm. They will be able to help you out with your immigration case. Don't forget the phone number is 216-279-3984, and they have offices in 9 cities of the United States: Atlanta, Chicago, Cleveland, Columbus, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one, 216-279-3984, 216-279-3984. We have the first question coming from the audience today, and this comes on our Facebook channel. And it says, hi, I entered on a tourist visa and stayed in the United States. Do my son need to file a waiver for me or only I-130 and 485? Thank you.
So if you enter lawfully, if you enter the United States lawfully, that means you are admitted or paroled into the United States, then you would be eligible to adjust your status inside the United States as long as you have an immediate relative petition. So an immediate relative petition would be either a spouse who's a U.S. citizen or a son or daughter over 21 who are U.S. citizens. Or if you are under 21, then you would have to have a parent who is a U.S. citizen. So in those situations, you do not need a waiver of your unlawful presence because you do have a lawful entry, and that would allow you to then file correctly an I-130 and I-485. The I-130 is the petition for an alien relative, and the I-485 is the application for adjustment of status, which would ultimately get you a green card. And you could do that all in the United States. You don't have to worry about filing a waiver, and you don't have to worry about returning to your country.
Okay, thank you so much, Attorney Noor. The phone number is 216-279-3984, 216-279-3984. The next question is coming on our YouTube channel, and it says, "Hi, I am from Colombia, entered illegally. My son is 21. Can he file for me? I've been here for 24 years.
Okay, so this is a situation where if you entered illegally, you would not be eligible to adjust your status inside the United States, and you do require a waiver. Now, the problem is that your son can petition for you if your son is over 21 years old. But there is a problem because even after your son petitions for you, you would require a waiver of your unlawful presence. Under the law, in order to qualify for a waiver of your unlawful presence, you have to show that either a spouse who's a U.S. citizen or a lawful permanent resident, or a parent who is a U.S. citizen or a lawful permanent resident would suffer extreme hardship if you had to go back to your country. Unfortunately, children or sons or daughters are not qualifying relatives in waiver applications based on unlawful presence. So unless you have a parent or a spouse who is either a U.S. citizen or a lawful permanent resident, even if your son files a petition for you, you could really not do much after that. You would not be eligible to adjust inside the United States, and unfortunately, you would not qualify for a waiver of your unlawful presence.
Wow, it's a very different scenario. In this case, even though it's a very similar situation to the prior question, but well, what do this person need to do in order to get immigration relief, Attorney Moore?
So, I mean, unfortunately, the opportunities are limited here. Now, obviously, I would have to sit down with this person and look at their history and see if there's anything in there that could qualify them for something. For example, if they were a victim of a crime or one of the specified crimes, then they could potentially qualify for a U visa. If they're afraid to return to their country, they might qualify for asylum. And of course, if they do get married to a U.S. citizen, for example, they could then have that spouse petition for them, and then they would at that point qualify for an unlawful presence waiver. But if the facts are as they are and they have no other eligibility for relief, then the options would be limited. They probably would not qualify for anything else, and they would just have to wait to see if anything changes either in the law or in their personal circumstances.
Okay, thank you very much for this answer. Don't forget, the office phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call. Just in case that you are in any of these cities, you can come to the office or you can call and make an appointment for the next trip that the attorneys are going to be in your city. The cities are Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one, 216-279-3984, 216-279-3984. We have a question that we left last week, and I promised that we were going to do it today. So Robin was asking, my wife got interviewed March 13 and forgot her nursing license original here in the United States and cannot take it to the interview. What can I do? Thanks. We mailed the original to Nepal, but it got lost in the mail. and another original copy took some time to get in the mail here in the United States. What can they do in this case?
So if your wife has a schedule, and I'm not sure when her scheduled interview is, of course, based on the question. If you're able to get a new original and send it to her or not. Otherwise, you could potentially also, if she needs to show that to the consular officer, you can potentially also extend or delay the interview to allow her to obtain these documents. The problem is that when you're dealing with consulates and consular interviews, if you cancel an interview and try to reschedule it, I don't know when they will reschedule it based on the country that you're in, because I know most of the consulates are very backlogged and they're scheduling interviews far in advance. So that may have her be stuck in Nepal for a while. So there's not an easy answer for that. I would have to know when the interview is and what you've been able to obtain and why you haven't been able to get it to her in Nepal. Potentially we could do a certified copy or somehow solve the problem, but you would still have to be able to get it to her. So that's something that I would need to talk to that person about more.
Okay, thank you so much for this answer. The phone number, don't forget, is 216-279-3984, 216-279-3984. The next question says, I am a 2-year green card holder and was assaulted by my wife. I am now divorced after filing 751 based on cruelty. Can I apply for citizenship based on approved 751 on cruelty?
Yes. So just to explain everything further, so what you got was a conditional permanent residency for 2 years, and you were required to file an I-751, which is a petition to remove conditions on your permanent residence status. Now, normally, the I-751 is intended to be a joint filing, meaning that if you're married to a U.S. citizen spouse, you're required to jointly file this I-751 petition with your spouse to show that you're still married, everything is still good, and then they would remove the conditions on your permanent residence, and you would have the actual lawful permanent resident status, what is called a 10-year green card. And then if you're still married to a U.S. citizen, obviously 1 year after that, just 3 years after you were originally granted conditional permanent residence, you would be able to file for naturalization and become a U.S. citizen. Now, the petition to remove conditions, even though should be a joint petition, has certain exceptions to the joint filing. One of the exceptions is abuse or extreme cruelty by a spouse. So in your case, that's what you filed. Because your spouse was abusing you, you filed it under the extreme cruelty exception to the joint filing. And if that was approved, then you would be eligible to file for naturalization. But because you're not actually still married to a U.S. citizen at that point, you wouldn't be able to do it in 3 years. You would just have to wait the 5 years to do it. But you would still be eligible to file for naturalization.
Okay, thank you very much, attorney, for this answer. And don't forget, you can call the office. The phone number is 216-279-3984, 216-279-3984. That's the phone number that you need to call in order to get in touch with the attorneys in the office of the attorney Margaret W. Wong, who has over 46 years of experience, and also attorneys like the attorney Noor that have a lot of experience working on the immigration field. So if you have any questions, please give us a call. The phone number 216-279-3984, 216-279-3984. And the next question says, thank you in advance for all you have been doing over the years. And special thanks to Ms. Wong for that client courtesy calls that she makes all the time. And she says, my mom petitioned for me August the 8th, 2017, and unfortunately passed away last year. I recently checked my current status online. The estimated time is 55.5 months, and it states that one can get in touch 27th July 2023. I realized that it's has already been for me 5 years and 7 months to date. I know there has been a mention to humanitarian. Let me check the full question here so I can see it. I realized that it has already been for me 5 years and 7 months to date. I know there has been the mention of humanitarian option, which means someone else would have to sponsor. My concern is that although my dad is a green card resident, he is quite elderly too. My sister is on a G4 visa. I am unclear as to whether she would be acceptable to sponsor me. And thirdly, I have my cousins who are US citizens. Please, can you advise me because I have a few options, but I don't really know what to do. And thank you for your patience.
Thank you. So if a parent petitions for you, and then ultimately they pass away before either the petition is approved or your visa becomes available. So technically under the law, the petition is automatically revoked because the petitioning parent is no longer alive and is no longer there. However, you can actually revive that petition under certain conditions, but one of the conditions is that you have to be living in the United States during that time. I wasn't clear from the question if you lived in the US or not. It sounds to me like maybe you don't live in the US because you're trying to see if you would be able to have somebody sponsor you to enter on a humanitarian parole. And I'm not sure what country this is from. So I don't know if it's one of the countries that currently are able to enter on a humanitarian parole or not. But if you are, then you could have your father or even your US citizen cousins file a petition of you to be able to enter on a humanitarian parole. But again, it's one of those situations where I would need more information from the person asking the question. But ultimately, the I-130 would be automatically revoked. It could be revived under certain conditions. I'm not sure if you meet those conditions. And as for the humanitarian parole, again, I would need more information about that.
Yeah, it looks like this person is from the United Kingdom, so I don't know if she qualifies for the humanitarian parole.
Right, and so you probably would. I mean, everybody can qualify for a humanitarian parole if you can show compelling humanitarian reasons. However, generally speaking, if you file for a humanitarian parole and you're not in one of the countries that currently the U.S. is allowing to enter more easily, it's very difficult to get a humanitarian parole approved. You have to have seriously compelling circumstances that would justify a grant of humanitarian parole, and it's very discretionary. So it's up to the officer based on all the information that they're given to determine whether or not you qualify. So unfortunately, it's not easy, and there are no easy answers in this case. The I-130 would, if you're in the UK at this point, would appear to have been automatically revoked, and there's really not anything that you can do about it.
Okay, thank you so much, attorney. And well, I have a question that is coming in right now, and it says, "Hi, I'm interested in EB5 Investor Visa. Can you give me professional guidance? I am from India."
So just as a note, I generally don't do employment-based immigration in this office, and I've generally not done employment-based. For EB5 Investor Visa, the only thing I can tell you is that there's certain requirements that you need to meet in order to qualify for it. And one of them is that you have to be able to invest a specific amount. And that amount under the law is either $1 million if it's in a normal area, but if it's in like say a target employment area, an under or an economically downtrodden area, then the requirement would be $500,000. There's additional requirements that you have to meet, including being able to employ at least 10 U.S. employees, and so forth. If you don't meet those conditions, you would not be able to qualify for an EB5. And it's a long process of applying for it. You have to have a business plan. You have to show that you have a viable business. You have to show that you have money ready to be invested. There's a lot of things that you need to show. But I would advise that you call the office and speak with one of the attorneys that normally does these types of immigration applications to give you a better answer.
Okay, thank you so much for this answer. And well, this question that is coming right now is very interesting. It says, "Hi, my ex-husband keeps threatening me that if I don't give him money, he will say to immigration that I married him fraudulently. I already have my green card for 5 years. When I married him, it was real. I had real feelings, but after that, he became a bad person. He started doing drugs and doing very bad habits, and I had to leave him. Now he has been calling me every single year that he wants money for this or for that, for the taxes, and I'm not giving him money because he's gonna use it for his stuff. We have a kid, and he's not even giving them any money for support. My question is, could I have bad consequences if he calls USCIS or ICE or whoever he will call to say that the marriage was not real?
So if somebody was to call and report something like that to immigration, they wouldn't just automatically act on it, number one. They would probably require more information. And if they did suspect that, let's say that you obtained your lawful permanent resident status through fraudulent means, including entering into a sham marriage, they would have to investigate it. That means that they would have to talk to you, ask you questions, look at the background, see if you actually had a bona fide marriage at the time. And if they determine that the marriage was bona fide, they wouldn't bother you. It's a long process. I don't know exactly where it would go from the first step. I'm not sure if he's serious about calling USCIS. He appears to be trying to extort you for money. That could be actually a criminal act that you might want to report to the police if you believe that that's what it is. But ultimately, even if he does report it to immigration, you wouldn't immediately be in danger of losing your status. Immigration would have to act on it. If they believe something was there, they would have to investigate it. And ultimately, you could have an attorney with you present to help you throughout the process if that were ever to happen. So my advice is to ignore that person, or if he continues to threaten you, then maybe report his actions to the police.
Okay, thank you so much, Attorney Noor. Our time is up for today, and thank you so much for all of your answers, for sharing all of your knowledge. And I'm looking forward to see you next time. There will be a next time, hopefully, and we hope to receive a lot of answers from you and your wisdom due to the experience that you have working on the immigration field. Thank you so much.
Thank you very much for having me. I appreciate all that, and I'll hope to see you soon.
Thank you so much. And for our audience, don't forget that the attorneys in the office of Margaret W. Wong and Associates, they are just a call distance. You can just call the phone number 216-279-3984, 216-279-3984, and they will be able to answer your questions, to give you advice in your case, and of course, to solve your immigration situation and get you an immigration relief when you qualify. So please write the phone number, give us a call, and get more information, 216-279-3984, 216-279-3984, attorneys in the law firm of Margaret W. Wong and Associates.